We are moving to the other part of the subtopic, which is removal. Removal of auditors from office. Removal of auditors from office. Now, in Kenya, the removal of the auditor before the expiry of their term is governed primarily by the Companies Act. And the process aims to balance the rights of shareholders to choose their auditor with the need to protect the auditor's independence and prevent arbitrary removal. So there are also rules that govern the removal of auditors, so that both the rights of both parties are respected. You understand? Now, one key point to note in removal of auditor is that number one is authority to remove. Who has the authority to remove an auditor from office? Number one, authority to remove. The hiring party is the one that has the power to fire. The power to remove or to fire an auditor lies with the shareholders of the company. And they can do so by passing a special resolution at the AGM. The shareholders have the power to remove an auditor through a special resolution at the annual general meeting. Shareholders have the power to remove an auditor through a special resolution at the annual general meeting. You recall we say that the Act aims to balance the interests of both the parties, the shareholders and the auditors. So before being removed, the auditor has a right to be heard. So there has to be notice and opportunity to be heard. An auditor cannot be removed arbitrarily. There has to be a notice that is issued. The company must give the auditor a special notice at least 25 days before the general meeting of its intention to propose a resolution to remove the auditor. And the auditor has the right to make representations to the company in writing or at the meeting. And such representations must be circulated to the shareholders. 28 days notice. He must be notified 28 days before the meeting to remove him is held. And he has a right to be heard. He can do so by writing, making written representations, or being heard physically at the meeting. Three, appointment of new auditor. It's important for us to mention this, that At the general meeting, at the same meeting where the auditor is removed, the shareholders must appoint another auditor to fill the vacancy. Then there has to be notification to the registrar of companies. Notification. The company must notify the registrar of companies of the removal of the auditor within 14 days of the resolution being passed. After 14 days, the company must write to the registrar of companies notifying or informing the registrar of the removal of the auditor within 14 days. This notice here is 28 days. The notification after it's removed must be made within 14 days. Are we clear on that? Now, one may ask, what are the grounds for removal of an auditor? What are the grounds? Now, the Companies Act does not explicitly list grounds for the removal, but some of the reasons include loss of independence or poor quality, poor audit quality. It could be due to breach of professional ethics and so on. Loss of independence. If the auditor's independence is compromised due to conflicts of interest or other factors, they may be removed. Because shareholders cannot just wake up and say you are removing this auditor. There has to be some ground for removal. And one ground, such ground is loss of independence. If the shareholders feel that the auditor's independence is compromised, that would mean that the auditor is not serving the best interest of the shareholders who appointed. Then the shareholders have a right to remove him on the ground of loss of independence. Another reason could be poor audit work or poor audit quality. If the auditor's work is deemed to be substandard or fails to meet professional standards, shareholders may choose to remove them. Another ground could be breach of professional ethics. Serious ethical violations by the auditor can also lead to removal. And other reasons could be maybe that the shareholders may have other reasons. The shareholders may have other reasons like disagreements. If the shareholders disagree with the auditors on, say, the audit fees, or if the shareholders desire a fresh perspective, then they have also a right to remove the auditor. Resignation. The auditor may be removed. The auditor may also choose to resign. An auditor can resign from their position under circumstances that are stipulated in the Companies Act. And even the resignation process is designed to ensure smooth transition and protect the interests of the company and the shareholders. And just like the case of removal, the auditor cannot wake up one day and say, I'm resigning. No, the auditor cannot do that. That is not allowed. That is not procedural. Before resigning, the auditor, first of all, must give notice of resignation. Notice of resignation. Notice of resignation. Notice of resignation. an auditor must give a notice of resignation. An auditor who wishes to resign must give written notice to the company, and the notice must be in the prescribed form, stating the date on which resignation is to take effect, and it must be accompanied by a statement of circumstances. Statement of circumstances. Number 2, statement of circumstances. So firstly, the auditor must give a notice of resignation, indicating the dates that you would want to step down. State the date on which the resignation is to take effect. The resignation must be in prescribed format and be accompanied by a statement of circumstances. Now, if the auditor resigns due to any circumstances connected with their ceasing to hold office, the auditor must deposit a statement of those circumstances at the company's registered office. What are the circumstances that led to the auditor deciding to resign? The statement of circumstances must be deposited with the company's registered office, and the statement is then open for inspection by any member of the company. So any member of the company should be able to know why auditor ABC resigned. Three, notification to the registrar of companies. The company must notify the registrar of companies of the auditor's resignation within 14 days. Within 14 days. Within 14 days. Then we must mention something on also appointment, the same we did here. Number 4, appointment of a new auditor. Appointment of a new auditor. Appointment of a new auditor. The company must take steps to appoint a new auditor to fill the vacancy caused by the resignation. That's a procedure for removal. That's a procedure for resignation. But again, one may ask, what are the circumstances that may lead to resignation of an auditor? What are the circumstances that may lead to resignation? One obvious circumstance is disagreement. Circumstances. One is disagreement with management. If the auditor has had serious disagreement with management, if the auditor has significant disagreements with the management regarding accounting policies or financial reporting practices, then the auditor may choose to resign. Loss of independence is yet another reason. Loss of independence. If the auditor's independence is compromised, they may be obliged to resign. Limitation of scope. Limitation number 3 of scope is another reason. Limitation of scope. If the auditor is unable to obtain sufficient appropriate audit evidence to form an opinion on the financial statements, the auditor can choose to resign. There could be other reasons that may cause an auditor to resign. It could be personal reasons. Maybe the auditor just want to retire from work, or the auditor is to change professions, or personal reasons that can also cause an auditor to resign. Other reasons. Or there could be other reasons due to professional commitments. So that is resignation.